Oh, yes, oh, yes, oh, yes. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention to the vast right-wing conspiracy is now sitting. Actually, we've got a more balanced program ahead, and looks like some volunteer paralegals for the Justice Department. Oh, that's my mistake. They were media. But in any case, God save the United States in this honorable court. Here's what we're going to do today and what we're not going to do. We're not going to give you the whole entire King v. Burwell arguments. You should have heard it already a couple times in the lower courts, and you'll hear it again on March 4th before the Supreme Court. But what we'd like to do is highlight in this first panel some of the important arguments you may not have heard as much about before, beyond the cycled and recycled main ones in the past 2.5 years of litigation across 4 cases that challenged an IRS rule that said it was authorizing tax credits for insurance coverage in federal exchanges under the Affordable Care Act. So the first panel will have some of the best of amici or amicus briefs filed in the Supreme Court case in King v. Burwell on appeal from the Fourth Circuit. Little quick background. Well, actually, before I hand out any awards for best performance, a quick historical recap of the ACA in this litigation. Its boyhood took some odd turns once people began to read the new health law to find out what it meant after it was passed in March 2010. The imitation game involved treating federal exchanges just like state exchanges, where enrollees were promised to be treated like they were guests of the Grand Budapest Hotel for health coverage. But then some American snipers took shots at the law, causing some legal whiplash and some lower court lawsuits. Several plaintiffs thought they could escape the individual mandate and be free as a bird, man, due to the unexpected virtue of ignorance of Congress, not them. But the theory of everything was supposed to explain what Congress must have meant while building a three-legged stool. You're on your own in trying to work Selma into this history. So,
Bridge too far.
Could be. Day job lawyer. Got to remember that. So how did we get here? It pretty much started in this room back on December 6th of 2010 at an AEI forum about other legal challenges to the Affordable Care Act. It wasn't widely attended. There were a little over 30 people, but it was sort of like Wilt Chamberlain's 100-point game almost 53 years ago in Hershey, Pennsylvania. Many more people today are claiming to have seen it back then and also in December of 2010. I even was going through my email and saw I sent a personal invitation to John Adler right before the event in December of 2010. And he caught up with it on the web in a couple of months, and after that, there's a lot of history in terms of how the arguments were developed. To save some time and keep our first panel focused on their particular legal arguments without relitigating the whole case in front of us, let me provide this very top-line synopsis of everything else that will be argued next week at the Supreme Court. There are lots of words in the ACA statute that makes interpreting the law quite a chore. This case and related ones aren't about constitutional law issues, but statutory construction. But in either case, lawyers know they have to read and use every single word because you never know which ones might come in handy. It's sort of like how the Native Americans used every part of the buffalo. The hide, the hooves, the horns, the organs, the bones, the sinew, and of course the meat. It was all put to good use and helped them survive. Nothing went to waste, not even the waste. They burned that for fuel. So out of the buffalo came almost everything necessary to daily life, including religious use as an intermediary through which the Great Spirit could be addressed, and by which the Spirit often spoke to them. So the buffalo was a big deal back then. The Indians revered it and thought it related directly to the Great Creator as a natural symbol. So in terms of using all the words, one of the first ways in which all the words are being used in this argument is one side's 4-letter word more important than a 4-word phrase. Such is getting a lot of mileage in the arguments of such exchange as being the overriding evidence that, in fact, the federal exchanges were supposed to have tax credits. On the other hand, in Section 1401, established by a state is a 4-word phrase, which would be the main contention of the plaintiffs' petitioners as to what the true meaning of this is. And then we're back and forth between Section 13.1, Section 13.11, and we're off on a ride for that. Now, those magic words make a difference in terms of what established by a state means. Let's give you a little basic geography overview on this. You're familiar with this map of the United States of America. Well, it turns out there's another map when we start talking about exchanges. This is the state of Burwell. It comprises a good number of states, not all of them, but it's certainly growing. Almost 3/4 of them, as a matter of fact. By some counts, 37 what used to be called states are now absorbed within the state of Burwell. In fact, they're working on their very own flag, the States of Burwell. This was stitched together, Betsy Ross style, by Kelly Funderburk for me over the weekend, but it's certainly a high-flying flag. Now, the other part of that legal argument is, when you do the parsing of this, that it's said that, there's terms of art, and we'll get into that later on, but that the federal government, the Secretary of HHS, is literally standing in the shoes of the states. So it's a comfy fit. I could understand why you would have thought this, back when Kathleen Sebelius was Secretary of HHS. She was a former governor. She just figured she'd just expand a little market share back in Kansas days. But in any case, we certainly have a different geographical configuration in the midst of these legal arguments. Now, this is part of a larger battle of manufacturing ambiguity. These are some of the magic words if you're playing a drinking game during the Supreme Court oral argument and want to see which ones get, top billing. We've got I won't go into all the arguments, but they're all convoluted, and you can, get more or less ambiguity if you want. Qualified individual is one argument. Within a state is different than other references to a state. Coverage month has its own particular nuance and nomenclature. Whether Medicaid maintenance of effort applies beyond 2013 in ad infinitum and under one set of circumstances. The requirements for coordination of the Medicaid and CHIP programs in states with an exchange, which might be a federal exchange, whether you could do that. Reporting information, which actually was in the Reconciliation Act, which would have set a budget trigger going off if it did what is alleged to be by the one set of arguments. And it looks like that one is sneaking under there, but that's final rule. No rules are final in this legislation, but occasionally they're said to be there. And there's also single pool that comes up on occasion in this. So a lot of the argument is, is it your history or mine, and why does this matter? Well, those of you who are not familiar with the Chevron doctrine, it's not about our good friend Hugo Chavez providing heating oil for us during the winter or his successor. It's how you interpret administrative rules and give a lot of deference to the executive branch in certain circumstances if you've got enough ambiguity to get past Chevron stage one. And whether there's a battle between the actual legislative language used in this case or the overriding policy intent. They meant to do it. That's good enough for some folks. We've also had some examples of recovered memories by congressional staffers who worked on this legislation, somewhat of a past life regression where they remember things that they didn't put in the law, but that's one way in which you can try to manufacture legislative history after the fact. A different argument, which we've seen in an earlier Supreme Court case, is Congress does not hide elephants in mouse holes. Pretty impressive mouse hole, if I say so myself. The argument that established by a state requirement for calculating tax credits was too hidden in the law to negate the broader intent of the ACA and failed to provide fair notice to states of what the consequences to them would be if they failed to set up state exchanges. You can make another argument with mouse holes and elephants in other directions in terms of other provisions in the law, so both sides can play with that one. The problem with a lot of this is that when you look at this law, we don't really know much about history. Folks who wrote it probably didn't know much about geography either, let alone algebra. But there's no conference report. There's no conference. That's probably why there wasn't a conference report. There was one committee report in the Senate. Lots of rewriting behind closed doors. So it's a murky task to play the usual legislative intent games in modern Congress these days. One of the intents that's argued by the folks defending and saying that's fine with the IRS rule is that Congress really wanted to reach near universal coverage, and that meant that coverage provisions and subsidies were supposed to apply to everyone nationwide, regardless of what state you live in. Couldn't get the insurance company logo, but maybe that'll be the next branding effort. We have to remember the history on this, which was that the Senate bill really controls most things. It was a take it or leave it. In March of 2010, the House had to swallow it, whether it might have preferred something else after the loss of the Kennedy seat in the 60-vote supermajority. bringing up echoes of the, I'm jumping ahead there. The Section 1321 federal changes were a backup plan in the event that the states did not do this. But here's the argument here that basically the legislation we ended up getting in the ACA was the last helicopter out of Capitol Hill, leaving the embassy in March of 2010 and probably leaving a lot of legislative history behind, or at least some cleanup in a conference committee. We've got another amici brief by the learned economic scholars, all 52 of them, most of the same old stuff. Three-legged stool is their favorite furniture. It's now called an essential pillar in the main brief, apparently after John Gruber fell off it without a leg to stand on. But all three supposedly have to be implemented together. The insurance rules, the individual mandate, and the insurance subsidies. Otherwise, we'll have hell on earth for health insurance. Massive losses of coverage, premium spikes, death spirals, bankruptcies, more deaths. And those are just the good parts. Economic models can show you this if you assume it's going to occur again and again in a linear manner. So the same consensus thing of these economic scholars that brought us the ACA and can't imagine any other way to advance goals of increased coverage and lower costs have produced these arguments. What a surprise. Okay, now we're waiting for the court decision, which wouldn't be on March 4th, obviously, but we've already got a glimpse of what's ahead for the near term. There you go. Are we getting here? Oh, I'm stuck. That's interesting. Let's see if I can go back. Let's see if we can do it this way. Looks like we're just locked or frozen for whatever reason. Okay. I'm about to give it up. Have no idea what's going on there. Okay, 10 more weeks of Obamacare enrollment from Puxatawny Phil. You would have thought it was 6 weeks, but they went to 10 under the argument that, well, it's close enough, and let's have a little bit more enrollment because some people might not be aware that they're about to be taxed and have to pay a mandate. Finally, let's remember that there's been a long time going on. It's not over till it's over. That's Yogi in the 1973 pennant race. So we've got a couple more months, and perhaps the way this legislation and the history of it has gone on, who knows even beyond that. But let's start off, that's a long enough introduction, with our first speaker, Tom Christina, who was here at the inception in December 6th of 2010. He's an attorney at Ogletree Deacons. He's a long experience in the Justice Department under several previous administrations. And Tom has filed a amicus brief on behalf of a good friend, Jeremy Rapkin, at George Mason University Law School, with a particular set of arguments in terms of what words mean and what they don't mean. And you can look at more of Tom's background in the bio. But Tom, take it away, please.
Thank you very much. I was thinking while Tom was talking, am I going to be expected to be that witty and to do it in that rapid fire manner? And when his slide stack got stuck, I was thinking, well, maybe it's an interim final slide. That's as far as the humor goes, I'm afraid. Ed, I've been asked a couple of times since December of 2010, well, what made you think of any of this? And the answer is I read the statute, but I read it with the tentative presumption that it could make sense, because I think that's really the only respectful way to read a statute. And in the amicus brief that I filed, I tried to point out some of the arguments showing that it does make sense, contrary to what the government and its amici say. So to begin with, there's a disputed phrase established by a state pursuant to Section 1311 of the Patient Protection and Affordable Care Act that is integral to the tax credit provision in the Affordable Care Act. And one of the things that seems so clear to me that makes me wonder why there was a dispute over this. Why would anyone pick a fight over the language? Is that the language makes perfect sense. It's also located precisely where one would expect it. Section 36B was added by Section 1401 of the Affordable Care Act. That's the only section that explicitly deals with premium tax credits. So it's naturally the first place anyone would look to see, what does, how does this work? What does it mean? And if you don't believe me, I invite you to look at Code Section 419A, which is the penalty for non-conforming, non-qualified executive compensation agreements. Exact same structure. And it is where an employee benefits lawyer would go to figure out, well, how does this work exactly? So I concluded that really the ACA doesn't suffer so much from a lack of clarity as it does from a lack of belief. People are unwilling to believe that the act means what it says. And as we've seen, mostly in print, not so much in the court filings, there have been a variety of approaches by the government and by its supporters to explain, well, it doesn't really mean what it says, or you can't understand it except holistically, which sends you to 1321C. And what I've tried to show is that going to 1321C really doesn't add anything. Indeed, it in many ways detracts from the argument because the conclusions have been things like the secretary stands in the shoes of the states. That's peculiar. I don't think there are examples of a cabinet secretary acting as a provisional government of a state. So I really never understood that one. And so there have been sort of increasingly sophisticated attempts to say, well, trust us, there is a way that those disputed words work out so that there is going to be an exchange in every state, well, that's true, and that there's going to be a tax credit available in every state. That, I think, is not right. And how is that consistent with Congress's intent, which is the next question, since I think the first question can't really be answered satisfactorily. And let me just briefly say why I think it cannot be answered satisfactorily. The disputed language either means what it says, and it makes sense as a plain text, or as the amicus brief submitted on behalf of former Solicitor General Charles Freed, among others, says it's a term of art. That would be a very peculiar thing, because ordinarily terms of art arise only after the art has arisen, which is why, for example, the phrase transcendental numbers in number theory comes up for the first time in, I think, 1648, whereas mathematics is old as the hills. And you can go through a lot of the arts and realize that terms of art, as opposed to definitions, don't arise simultaneously with the creation of the art. And I don't think there was an art of exchange creation prior to the ACA. So the argument that this is a term of art ultimately is really an argument that this is code. And it's a very weird code, because in order for it to be successful, to work successfully as code, the encrypted text has to mean both what it says and what it doesn't say. So the process of deciphering would be particularly difficult. And it's all unnecessary, because all you have to do is read the statute. And when you read the statute, you realize that such exchange, as used in 1321C, does not refer to an exchange established by a state. In fact, the premise of that language is that the state has decided not to establish an exchange. So now let's go on with the question of congressional intent. There could be a very prolonged debate about congressional intent. I don't plan to get involved in that debate. I would just urge you to recall that you shouldn't be confused by the grammar of the phrase congressional intent. Think about the easier concept to understand, transferred intent. Does transferred intent describe some activity in the brain? Well, no, it doesn't. It's a policy decision that if A aims at B with his gun and is a bad shot and ends up shooting and killing C, then he has sufficient mens rea to be tried for murder. So congressional intent doesn't necessarily mean the intention of particular legislatures or anything else that can be tied back to a mental event. And now, actually to conclude, naturally you don't want to interpret a statute, if you can avoid it, so that the thing just turns out to be irrational. And I don't think anyone is any longer claiming that that is the case here. But you might wonder, well, why? Why? Let's suppose that we didn't have a legislature, that we just had a benevolent dictator, and that benevolent dictator ordained in the form of this statutory text what was going to happen. Why in the world would the dictator do that? And the answer is actually right there in Section 36C, for everyone to see. The purpose of the act was to widen coverage, but not just coverage through exchanges, also coverage through employment. So when you look at 36C and you see that elaborate section about offers of coverage to people who are employed, part of the reason for that is that it dovetails with the employer mandate penalty. So that the purpose, one could say, behind that section and behind the disputed words is to allow the states to decide, well, in my state, which would work better? Will my state be better off risking its economy and risking employment, or will it be better off, with tax credits for premiums? It makes perfect sense that devolution would be the rational thing to do in this situation. And so I think when you read the statute, you just uncover or recognize that it is a coherent whole, And I guess that's really it.
Thank you very much, Tom. Our next speaker is Ilya Shapiro, noted for his great legal work at the Cato Institute for a number of years, very much a constitutional scholar, but also able to construe a statute when necessary. It's part of the day job on occasion. He's also filed a amicus brief or amici brief on behalf of both the Cato Institute and Professor Josh Blackman, which takes a little bit of a different take in terms of let's get a little context of the rap sheet for the folks who brought us the IRS rule in a larger context. Ilya?
Right, exactly that. I don't like to parse the text too finely. I'll let other people do that. So we took kind of a 50,000-foot view and filed what's becoming known, or at least what we're calling, the rule of law brief, documenting the pattern of violation of separation of powers and the rule of law more broadly in Obamacare implementation, and indeed more broadly. Last week with the immigration ruling, I found myself talking to a lot of reporters, both on that subject and on this subject, and I admit I would get confused because my analysis was essentially the same. The president was making up, rewriting the law, not implementing some things, implementing others of his own invention. There was one conversation with a reporter, I think I was 5 or 10 minutes in, and then he asked me a question, and I realized that we were actually supposed to be talking about the other subject. I can't remember whether he was calling about immigration or this one. But anyway, and I said, oh, I apologize. Everything I've said in the last 10 minutes when I said the immigration laws, just substitute Obamacare or vice versa, because this is the troubling point here. I mean, we make light, but there's an incredible pattern here of there being a law passed by Congress, its consequences not being consistent with executive preferences or not convenient politically. Congress won't act, and therefore the president somehow gets more powers to do it himself. Now, I will admit, I am a simple constitutional lawyer, as Tom said, and when people ask me a constitutional question, I tend to look at the actual Constitution. Y'all can follow along in yours. This is the special Cato Constitution. It's a twofer. You buy the Constitution, you get the Declaration for free, and this is actually the limited edition Shapiro Wedding Constitution with my wife and I, our names here and the date, and so our guests all got that. My wife's a very tolerant woman, as you can see.
That wouldn't be the Constitution in exile, would it?
Well, look, unlike, I can't speak to any other pocket constitutions, but we don't excise anything, we don't add anything in, and we vouch for the entire document. And our brief here really was an outcrop of kind of a periodic op-ed I do on Obama's top 10 constitutional violations. I did one in 2011 for Daily Caller. I think it was one of their top clicked op-eds. Did another one for Forbes a couple of years ago. Also, I think it's up to some like 400,000 hits. I mean, it's like shooting fish in a barrel. It's disturbing because how could it be so easy to rattle off a president's constitutional violations? And so Tom told me to stick by my brief, quite literally, which I will do. I'm not to go into the overall landscape of the arguments. And what I have to say is that this case is about much more than statutory interpretation or Chevron deference in administrative law. It's about the separation of powers and the rule of law and the systematic deviance from waiver of the Patient Protection and Affordable Care Act, the most wide-ranging law of our young century. I mean, look, I would love for President Obama or HHS, Secretary Burwell, to just suspend all of Obamacare indefinitely. That would be fantastic. But they don't have the power to do that, and yet they've been doing it again and again and again in different specific provisions. And we can talk about the different legs of the stool, right? The way Obamacare operates is first, there's a mandate imposed to penalize people that don't have minimum essential coverage. Then there's an employer mandate to penalize employers that don't provide people with this minimum essential coverage. And finally, most relevant to this case, there's a Rube Goldbergian system of subsidies and tax credits for states choosing to establish exchanges. And it's nothing new, the idea that Congress wanted states to do to do something, the idea of cooperative federalism. Even in Obamacare, states were supposed to expand Medicaid. At first, they were coerced too much, the Supreme Court said, but now they can do it voluntarily, and so we have half the states expanding Medicaid and half not. A funny thing happened on the way to utopia, and just like with Medicaid expansion, very few states chose to establish exchanges as well. That's not what the designers of Obamacare really expected, to the extent anyone really knew what was in the legislation, but that's what happened. And so when what's become a troubling pattern of abuse, the executive branch has modified, delayed, and suspended all three legs or pillars of the Affordable Care Act through a series of memoranda, regulations, guidances, even blog posts. Executive officials have disregarded the statutory text, ignored legislative history to the extent that's relevant, and remade the law in their own terms. This executive lawmaking poses a severe threat to the separation of powers principles that undergird the Constitution and ultimately the rule of law itself. Now, if you read my brief, it's a compendium of all of these suspensions and waivers. First, there's the so-called administrative fix, because if you like your plan, you can keep it. Oops, you actually can't. The way Obamacare is designed, obviously a lot of plans were non-compliant. They didn't cover all the bells and whistles that were necessary, and so this fix was announced. HHS offered exemptions to the mandate and penalty that were inconsistent with the statutory text, codifying this administrative fix because Obama's "if you like your plan" was the lie of the year, according to PolitiFact. And so once again, faced with a statute that yielded politically unpopular results, the administration suspended the enforcement of the mandate and penalty for millions. In effect, as noted Obama supporter Ezra Klein put it, Obamacare itself is the hardship that the Secretary was claiming to offer waivers to people such that they would no longer be subject to the individual mandate, tax, penalty, whatever you want to call it. I call it the unicorn tax, a creature of no known constitutional provenance that'll never be seen again. Then we go to the employer mandate, which is the one that was, because it was inconvenient for employers to suffer the pain, was first delayed for a year and then changed completely and suspended, and who knows, kicked down the road until right before the election next year. And it was initially suspended, the employer mandate, via blog post. This is no joke. A blog post that was ironically titled, "Continuing to Implement the ACA in a Careful, Thoughtful Manner." Suspending the employer mandate was a careful implementation. And then an IRS notice memorialized this action, citing no other authority than the blog post itself. And the blog post was issued on the eve of the 4th of July holiday back in 2013. And then, as I said, the employer mandate was changed, suspended again. Different tiers of employers, not just small and large, but there's a medium tier sliding scale of implementation, a 70% transitional mandate, 95% final threshold. None of this is in this might make sense. It might, as a transitional matter, it might make sense permanently. I'm not a health policy wonk, but I can tell you it is not in the 2,700 pages of the law. The president himself called it a temporary modification to the health care law. This is kind of like him saying that he changed the immigration law because they needed to be changed. There's no such provision in the Constitution that allows the president to make temporary modifications to the law until Congress gets its act together. Most importantly, perhaps, it frustrates the design of the Affordable Care Act to make it easier for business to transition. The point is there's going to be some pain. You kind of cross-subsidize. It's a very big transformation, for good or ill, of the law. And here the administration is walking back its own law, in effect, providing less coverage. If the idea is to have affordable coverage for all, here all of these modifications, no question, they make it politically more convenient. Perhaps they make the policy easier to implement. I don't know, but they certainly contribute to less coverage overall. And the IRS rule is more of the same here. I won't go into its sordid history, but to paraphrase Inigo Montoya from The Princess Bride, Congress didn't think expand coverage means what the executive thinks it means. Here, it wasn't advancing coverage, by all and any means. It means the states were to be involved here. Congress couldn't command the states. Congress, it was more politically feasible to have a state role. And so again, you have this executive lawmaking with a law that's inconvenient in effect or politically, and so the executive legislates. And it happened in other examples as well. Waiving congressional staffers' required entry into Obamacare. That one didn't really make too much news outside the Beltway, but it was a huge deal, and Obama sort of issued a guidance in the doldrums of August of 2013 when everyone was on vacation to make that waiver happen. The territories, application of Obamacare to the territories, their markets are so small that it would really decapitate them to implement all of the requirements of the Affordable Care Act. And so after 3 times of saying, no, we cannot waive these requirements, I'm sorry, all of a sudden, I guess the text of the law magically changed, and the administration found the authority to do this, I guess because, again, congressional gridlock gives the president license to transcend his executive power. Look, as a wise man said in NFIB versus Sebelius, it's not the role of the court to express any opinion on the wisdom of the Affordable Care Act. Under the Constitution, that judgment's reserved to the people. But when the judgment of the people, manifested by the laws passed by Congress, is itself disregarded, it remains the duty of the court to enforce those limits under the federal government of limited powers. The court retains the singular function of safeguarding the separation of powers where Congress can't do so alone, and enforcing a statute is a very different type of process than deciding whether to defer or not to Congress to give it the benefit of the doubt on whether it has the power under the Constitution in the first place. For, and this is quoting Justice Scalia now in the recess appointments case last year, in any controversy between the political branches over a separation of powers question, staking out a position and defending it over time is far easier for the executive branch than for the legislative branch. Because of the executive's deliberate indifference toward the congressionally designed ACA, the separation of powers, and the rule of law itself, this is just one more reason why the court should not defer to the IRS any more than it can throw it, and it should reverse the judgment of the lower court. Thanks.
Thank you very much, Ilya. As Inigo Montoya would say, inconceivable. You killed my health care coverage. Prepare to see it die. All right, those of you who don't watch these movies often enough. Our next speaker is Abby Gluck. She's a professor of law at Yale Law School, incoming faculty director of its new Solomon Center for Health Law and Policy. And she's quite well positioned to be talking about this particular issue as an expert on legislation and statutory interpretation, Congress, federalism, and health law. Didn't leave anything else out there. And she, among other past backgrounds in government, she was counsel to the New York City's deputy mayor for health and human services, but that was Bloomberg, I believe, not Rudy, in this radioactive environment at the moment. And she's also has a new casebook with several co-authors, Statutes, Regulation, and Interpretation, Legislation, and Administration in the Republic of Statutes. She's filed a very significant brief, I think, as both counsel and one of the amici on the a fair notice argument under cooperative federalism, which we need to take into account in terms of how the Supreme Court might be viewing these issues. Abby, thank you.
Okay, thanks, Tom. We're having some strange electrical connection issues here. Can everybody see me and hear me right now? Can nod if you can. Okay. Well, we'll do our best. It tends to be freezing every couple of minutes, so if it doesn't work, we'll just go with it. So I'd like to thank Tom for inviting me, and I apologize I can't see my other co-panelists in person, but I'd like to say hello to them as well. So I'm very grateful to be included in this discussion of the other off the beaten path arguments in the case. And my role here, as Tom said, is to talk about the federalism issues, which we brought to the fore in a brief that I filed on behalf of Tom Merrill at Columbia and myself and some other federalism scholars. But what I think is actually the most interesting thing about this invitation is the fact that the federalism arguments have had this sort of off the beaten path, tangential feel to them until very recently. And the argument I want to make to you here is that it really misconceptualizes the case to think about it as anything other than a federalism case. And the reason that is that the case is about the way that Congress designed modern statutory schemes with roles for the states. It's about the drastic consequences that the states are going to face. Many people think it's going to be the collapse of 34 state insurance markets if the states exercise their statutory option not to implement the ACA itself. And it's about how much notice is due to the states. Notice that the Virginia brief, as you know, on behalf of more than 20 states, as many others did, a test was lacking. And even through the intensely scrutinized period of ACA enactment, debate, and the 2012 Supreme Court case, this is something that nobody noticed. These dramatic consequences were not even talked about until this case was developed. So in my view, if this isn't the most important kind of federalism question today, in an era where we have big states, where the big states' rights issue is their roles in federal statutory schemes, I don't know what is. I've been writing on this question for a long time now, long before the case was ever existed, about how to preserve federalism in an era of federal statutory power. And King really puts these issues front and center. Read as the challengers would read it, this would be the most draconian cooperative federalism statute in U.S. history. That's no exaggeration. So, of course, it's not a case just about federalism. It's also a case about statutory interpretation and textualism. And I don't have to tell the crowd at AEI that textualism and federalism have always been related, right? Textualism is in many ways a direct response to what was perceived to be an era of judicial activism and the expansion of federal power. Textualist judges and scholars developed these interpretive tools in an effort to enforce principles of federalism and separation of powers. And to do this, the court has developed a deeply entrenched array of legal doctrines that it uses every single term, in case after case, every time the role of the states in federal statutes is implicated. For those who aren't lawyers in the room, let me just briefly tell you what those doctrines are. Right? The first is the so-called Pennhurst rule, and it requires that when Congress imposes conditions or consequences on the states in federal statutory schemes, those conditions or consequences must be crystal clear. And it tells the court it can't read a federal statute to impose those kinds of conditions or consequences unless the statute is crystal clear. The second iteration of the doctrine is usually called the Gregory Rule, after a case called Gregory versus Ashcroft. And it similarly says the federal court should not interpret statutes to disrupt the traditional state-federal balance unless Congress was explicitly and unmistakably clear. The doctrine should sound familiar because they were at issue in NFIB versus Sebelius, the 2012 constitutional case, but there they were invoked by the other side, right, by the Obamacare challengers to strike down the Medicaid expansion, and they were very successful in that case. They were accepted in that case by 7 justices in ruling to strike down the expansion. But they weren't invoked at all by the challengers in King, right? Despite the fact that that challenge is grounded in textualist philosophy. And obviously that's because these principles cut in favor of the government this time around, right? The challenger's reading works a dramatic intrusion on the states. And we're not just talking about individual people whose consequences, of course, should not be overlooked, but we're talking about the intrusion on state governments, state insurance markets. This is sort of the core governmental protection that these federalism doctrines are supposed to protect. And as most people watching the case know, if the challenge is successful, the reason the state insurance markets are likely to collapse is that those markets can't support the ACA's nationwide insurance reforms without the additional customer base that the subsidies are designed to provide. That's a drastic consequence, right? One that state after state, numerous government officials, and virtually all the media who covered the ACA through enactment said was never communicated to the states in any way, and it doesn't appear in the statute. It's also worth noting that this puts the states to a choice that is not a choice at all, right? Everyone agrees the challenger's reading will put the states in an untenable position that would have to be addressed. But the federalism doctrines also require that as a constitutional matter, states have to have the true option to participate in federal schemes. And there's another set of important doctrines the court applies that says when a particular reading of a statute raises a potential constitutional issue, you go with the other reading of the statute unless the statute is crystal clear. But it's not. What does appear in the statute and what the challengers rely on are 4 words in a provision of the Act that is directed to the individuals in the calculation of their taxes. That's not where one would expect to see a consequence of this magnitude. And even if the four words said what the challengers say they just don't satisfy the level of clarity that the court has required in previous federalism cases. Instead, when you look at the provision of the statute where any such consequence would actually belong, the section that sets out consequences of what happens when states don't establish their own exchange, that's 1321, you see there that section is entitled State Flexibility. And the subpart is also called state flexibility. You see within that section a subsection called failure to establish, exchange, or implement requirements, which spells out the consequences to states of not operating their own exchanges. The penalty the challenge was foist on the states does not appear there, nor does any other penalty, and that's where it should be if it existed. As further textual support, all one has to do is look at the Medicaid provisions of the ACA itself. By comparison, those conditions also make clear that the states had to expand Medicaid to 138% of the poverty level or forfeit all their funds. It's important to understand also, by the way, that what was issued at FIB was not whether the statute was clear, but whether that provision was coercive. The clarity of the choice was never contested. And so here's another black letter doctrine we need to invoke. When Congress shows and knows how to speak clearly in one section of the statute to an important issue like states' rights, the court doesn't infer from another provision of the statute that Congress means to do the same thing unless it's clear. The difference between the Medicaid provisions and the way the exchanges are structured is also critical to understanding the case because in an important sense that hasn't really been emphasized a lot. The entire King case is based on this idea that the whole ACA adopts the same sort of scare the states into submission philosophy, the same way the challengers read Medicaid to do. But it's just not true. You don't take my word for it. The 2012 NFIB dissent laid out the structural difference, as did the 2012 briefs for Florida in the same case. I'm just going to read you a quote from the Florida brief. This is the quote. The ACA expressly renders enrollment in Medicaid a means of complying with the individual mandate, but provides no alternative mechanism through which the neediest of individuals might obtain insurance in a state that declined to participate in the new Medicaid program. The context with the other components of the ACA is telling. For example, the ACA's health benefit exchange provisions, which offer substantial new funding to states willing to implement such exchanges, expressly provide that the federal government will create and operate an exchange if a state declines of federal funding. That's pages 12 to 13. So people in this audience know by now that Congress has more than just one note to sound when it comes to federalism and federal statutory design, right? Congress uses a lot of different structures when it legislates to include the states. One structure is the Medicaid structure, a federal grant that states use or lose. And every statute in the U.S. Code that I have found, and our brief lays this out, comes with an explicit condition and consequence when it comes to Medicaid. The exchanges, as the quote from the Florida brief makes clear, have a very different federalism structure. They're on the model of statutes like the Clean Air Act, where there's a new national regulatory scheme. States are given the right of first refusal to implement part of it, and if they don't, the feds step in. But when the feds step in, the scheme is still implemented when they do. And to my knowledge, there's no other cooperative federalism statute in the entire U.S. Code that uses a federal fallback that provides, as the King challengers would, that the federal fallback, and with it the statute's primary reform, here the insurance reforms, collapse to pieces as soon as the federal fallback is triggered. So just step back and remember, this is my last point here, just to step back and remember that in an age of massive federal power, the most important tools that states have is advance notice of what federal statutes are going to do to them. That notice is the only way that states can make their voices heard in the federal political process. Here, the King challengers are asking us to believe this dramatic, unprecedented, and perhaps unconstitutional consequence was made crystal clear when the ACA was enacted, but no one, no state, no Federalist senator, no blogger objected to it. Indeed, nobody even mentioned it for 2 whole years. I understand the statute is not loved by a lot of people, and I'm guessing it's not loved by a lot of people who I'm looking at through the little TV screen right now. But King isn't just it's just not a one-off case, right? Just because it's not a constitutional law case, it doesn't mean that it doesn't stand for some very important legal principles. The court has worked long and hard to develop and entrench these federalism doctrines in its statutory interpretation jurisprudence. I'm a legislation professor. Legislation professors like me, we teach them to the students. We write them into the case books. We tell our students to rely on them as lawyers in litigation. That's a success for this federalist movement. But if these doctrines are actually legitimate, they have to apply regardless of whose side they support. This time they happen to support the government. Thanks.
Thank you very much, Abby, and for doing this at a bit of a distance and a technology boost. We do appreciate it. I need to correct the record on two things. I can't believe I made an inconceivable mistake. It was Vizzini, not Diago, Inigo, who said inconceivable. And also, when I was running through the backup plan slide, I forgot to mention that, in fact, there were some federal fallback exchanges written as a backup plan in a different means, which showed that Congress did know how to condition funding and attach it to a federal fallback exchange. If you look at the Senate Help Bill 1679, reported out in September, it actually first had a early gateway if the states wanted to play ball with that, which gave some money to the federal gateway and put that funding in there. And then 4 years later, if they did not decide to set up their own exchange, then you had a federal fallback, which did not have money until the states decided to bring state and local governments under. So they had the means and the opportunity and the language. Just turned out it wasn't there in the final law. We've got a little bit of time, maybe about 10 minutes for some audience question and answer, where you can't tell what will happen when you turn these lawyers loose on a wider playing field. But we'll see if anyone has some brief questions before we move to our second panel. Do we have a microphone roaming about in any case? Again, you get about as much time to make your argument as you do at the Supreme Court, and you'll be interrupted quickly. But take a shot at it while identifying yourself, and then we'll basically pepper you with our own set of questions. Anybody in that regard? Otherwise,
Tom, with the technical difficulty, I thought you'd be making a joke about Frozen as well.
Abby was not the poster child for healthcare.gov. I think I was another terrified woman who had her brief moment of notoriety. But we do appreciate her being here under extent. I think she can hear what we're talking about right now, so she could be part of the Q&A. If in the event that we don't have any, looks like pretty much unanimous ruling. Go ahead, Tom. Tom Haynes.
Yeah, I'd like to ask Professor Gluck a question. Oh, up there. Okay, thank you. If the court concludes that the language is clear, yet agrees with the argument you make in the amicus brief, A, would that make the ACA unconstitutional? And B, to the extent it does, would you have a viewpoint on various severability implications of that?
Well, okay, so I think I heard all of that. I also think I heard Tom before talking about the Health Committee bill. Is that right, Tom?
That's correct. Yes,
Right.
yeah. Oh, sorry. Yes,
Question
correct.
I'll answer this question in a second, but the Health Bill, that provision did not make it into the final statute. And there is a statutory interpretation doctrine called the rejected proposal rule, which says that when Congress has an explicit provision in a draft statute, it doesn't make it into the final statute. You construe the final statute not to say what the draft provisions said. So I've written this before. I think the Health Bill works very much in favor of the government. Just word to the wise. So
We've got some other precedent too, but that's okay.
What? Sorry, what?
We've got some other precedent too in terms of what Congress knows and what it does, but that's fine. Move on to the next one.
Okay, sorry, I missed a little of that. Let me get to the audio is not that great on the Q&A.
Sure.
On the constitutional question, the brief I filed didn't take up the constitutional question, but there is a brief that was filed by Professor Abigail Moncrief at Boston University that does argue that if the federalism provisions, if the federalism arguments are construed in the way that we would read them, then the statute would probably be unconstitutional because of the choice that it puts to the states. I think that'd be a question that we'd have to remand for further briefing and review. I personally think it'd be ludicrous if the court got this far and we couldn't be talking about severability right now because we haven't had any briefing or exposition of that kind of argumentation. It would just be premature.
Okay. One question. We move back there.
Carl Polzer. Just seems like from a strategic point of view, this might be one where if you win, you lose. Because, like a state like Virginia, where I live.
Carl, if you're talking about policy and consequences, that's coming up on our second panel as opposed to legal arguments. I'll recognize you at the back end of that if that's where you're going.
The other thing is, the Supreme Court has been known. What am I doing wrong? Oh, this way. They do jazz sometimes, Tom. They don't always have clear, black letter law when they act, like in Marbury versus Madison. I don't think in the Constitution there is anything said about the Supreme Court or much. Just a note.
Make it up as they go along on occasion, but it's been known to develop a line of authority. I think what we're going to do at this point is usually a popular move. We're going to kill all the lawyers on the first panel, or at least the full-time lawyers, and we're going to do a
I
pivot.
just play one on TV.
Okay. We'll do a pivot. Well, you're welcome to stay if you want to. I also want to, Abby, you're welcome to stay on if you want to, but you can also go on to other things as well. We're going to be talking in this part of the panel discussion about the possible effects. And this is a one-sided hypothetical because I think we got a different set of consequences if, in fact, the petitioners lose. It's less of a story, and we could go down that road, but we're going to focus on just what happens the day after if the king petitioner plaintiffs win. And for the purposes of this discussion, we're going to have Ramesh Panuru and Tom Haynes talk, and I'll have some comments as well. But first I have to find my handy-dandy next set of slides, which would be where?
Tom, thank you. I'm going to sign off because I have a meeting in about 20 minutes. I really appreciate being included in the conversation.
Okay. Thank you very much, Abby. We do very much
Thank
appreciate
you.
your participation.
Bye-bye.
Okay. Okay, folks, I'm trying to find where my next thing is hiding. That wasn't it. This is called technical help. I need to bring up next deck of slides.
I think they're
Oh, they're already there. Well, I was looking over here, so they didn't exist. It's a parallel universe. Okay. So we're talking about, kind of quickly, not the 1983 television film of nuclear holocaust the day after, but the view that if the king petitioners win, things will be a little sticky. The administration certainly has had a strategy for this. What its basic approach has been is to start tying up more hostages. Dudley Do-Right's Nightly Whiplash style. We've got enrollees currently in the federal exchanges, federally facilitated marketplaces, and other hybrids thereof. We've got other insured premium payers who are supposed to be at risk because their premiums will go up as a spillover in single pool pricing in the individual market and small group market. We've got insurers being tied up as hostages, and also hospitals being tied up and about to go under, being hostages without the funding. New federal programs, I believe. You're familiar with AFDC. I think there's two other ones called AFDI and AFDH, Aid to Families with Dependent Insurers, and aids to families with dependent hospitals. All those are the scenarios if the court rules for the petitioners and the government and Congress does not immediately restore, and that's basically Dudley Do-Right coming in there to save the day by quickly untying the knot and adding water to the package mix and letting the money flow to the old exchanges once again. We've had some claims that in the event of the petitioners winning, there would be a disaster of, if you will, biblical proportions, somewhat Ghostbusters style, which sounds like things would be pretty dark. Looks like that got cut off at the bottom. At the very bottom there is human sacrifice, dogs and cats living together, mass hysteria. That's one step short of the ultimate sign of the end times when Democrats and Republicans agree on bipartisan legislation. That's Ghostbusters 1984. The third one's coming with an all-female cast. They're advertising for the next remake of that. We also have the dire forecast for what's going to happen to all the folks who are covered under Obamacare or the Affordable Care Act and the federal exchanges with tax credits. The newly reinsured will be somewhat about to die, but not quite yet. The Walking Dead, any moment. Season 2 is season 2 of enrollment. I used to think that those were the folks who were just waiting to enroll in the first season and were looking at a frozen screen, but it depends upon your perspective on that. In any case, office holders, federal and state, are going to have to deal with something if the Supreme Court rules against the IRS rule. I don't want to say it's a game show, and it looks like the format's not coming through there, but it's an old show from the late 50s, early 60s, Truth or Consequences, in which a young Bob Barker would ask the contestants either to answer a question truthfully, perform a stupid stunt or trick. We know what the normal choice is among office holders, and we've seen that in terms of their legislative output. But in forecasting ahead, the thought is that it'll be hard to get Republicans in Congress and related parts together on this. There'll be a splintering. They'll be pretty divided. People will start saying some extreme stuff. It's actually been remarkably surprising how much discipline and unity there's been thus far. Now, it's not the final action, but it suggests that, in fact, it's about as good as it can get among Republicans at the moment, and they're not selling crazy these days because they're all stocked up after the last government shutdown. There are those who think that if, in fact, the Supreme Court case is won by the petitioners, bye-bye Obamacare, bye-bye federal exchanges, it's all over. That's not really the case. We're going to have an extended period of time to work these things out, and so it's fair to say that the Obamacare exchanges, even after a King decision in that direction, would be not dead yet. But with that starting point, we're going to turn to Ramesh Panura of National Review and AEI, who has as good a feel as anyone for what congressional Republicans might do or thinking about doing or should do. Sometimes those aren't all the same subject. But we asked Ramesh to outline at least his view of the policy options likely to be on the table. A little hard to vote before something actually changes in the law, although people would like that to happen in some cases, to give us a little bit of a thinking as to what might be the levers in play and the options on the table for getting ahead rather than going further behind. Ramesh?
Thank you. I am not going to try to replicate that impressive range of cultural reference in laying out what Republicans may or may not do about King v. Burwell. I think the first thing to keep in mind, sort of my central rule of thinking about how Republicans on the Hill will approach this issue, is that there are a lot of congressional Republicans who will just do anything to end Obamacare, with the exception of thinking about health care policy. And since they're in many cases not willing to do that, they haven't really done a whole lot of contingency planning, although there are working groups and there are some Republicans who are thinking about it. There is certainly nothing like a consensus on where to move. There are a lot of Republicans who've been sort of cheering this case on from the sidelines under the assumption that a victory by the plaintiff means the death of Obamacare. There are also some Republicans, a smaller number I'd say, on the Hill who are following this with some concern, possibly even dread, because they think that a plaintiff victory is a much bigger problem for the Republicans than it is for the Democrats. If you think about the Democratic response to plaintiff victory, it's pretty easy. On the one hand, attack the Supreme Court as having ruled in a partisan and illegitimate way, and we basically know what that line of attack will look like because it's essentially been previewed in all of the liberal arguments about the case. And then second, urge the state governments to establish state exchanges and qualify for the subsidies, and urge Congress to pass legislation that would be, I assume, would fit on one page, maybe 2 or 3 sentences, that allows subsidies to flow to states that haven't established exchanges. The argument here will be pretty simple. This was a lot of people are seeing their health insurance threatened. Congress can pass a simple fix. Let's do that. And if Republicans balk, of course, they will be held responsible for the plight of people who thought they had health insurance and then suddenly find that they don't, which is several million people. And I would say probably it doesn't just include the people who are themselves receiving subsidies, but people whose health insurance is in some way linked to the health insurance of people who do receive subsidies by being in the same pool. So Republicans, I think, do have a little bit of a problem here if the plaintiffs win. They've got a few options, which, as I said, they're still sort of in the early stages of thinking through, even though time's getting short. And I'll present these in no particular order, except that the one I want is the last. The first option Republicans have would be simply to acquiesce to the demands that the administration will certainly make to pass that simple bill, that simple fix that does solve the problem of people who had their health insurance at risk thanks to the decision, or rather, depending on your point of view, thanks to the administration's decision to go ahead with illegal subsidies and the court's decision to call them on it. But at the same time, there are some pretty substantial defects of this course of action. The first being that it is a huge, huge problem with conservative Republican constituents of these Republican office holders. They would say, and I think they would be correct in saying, that the Supreme Court had just invalidated a large chunk of Obamacare as going beyond the law, and that the Republican Congress had just affirmatively decided to expand Obamacare by billions and billions of dollars. That is not something that any congressional Republican wants to go into the next round of primaries boasting about. And this would also be an affirmative choice to expand a health insurance program and entrench a program that most of these Republicans believe is very much misguided and the wrong direction for American health care. But I think that a lot of Republicans who don't think they want to go with this route now may find that under the pressure of changed political context after the decision, that it starts looking more attractive to them. But there's no question it would be a huge, huge internal problem for the Republican Party. A second option would be to acquiesce to a permanent extension of those subsidies for states that haven't set up exchanges, but in return for something. Let's make a deal. The something could take various forms. Could be getting rid of the individual mandate. It could be getting rid of the medical device tax. It could be changing the rules by which the exchanges are governed so that they are less heavy on regulation, less prescriptive. It's sort of hard to evaluate this since there's so little consensus on whether to try this route. There's certainly no consensus on what the get would be, what Republicans would ask for in exchange for the exchanges, so to speak. But I think it's pretty hard to thread the needle here. It's very hard to see something that conservative Republicans would consider enough to compensate for expanding the subsidies, that President Obama would not consider too much, so that he wouldn't veto it, or the Democrats in the Senate wouldn't filibuster it. And it's actually pretty easy to think of things that would fail on both counts, that the Democrats would want to block and the Republicans wouldn't go for in substantial numbers. I think that there are a lot of folks on the Hill right now who are attracted to the idea of a deal. But I think the more you move from idea to reality, the less there's going to be to negotiate there. A third option would be do nothing. This would be, I think of it as the sort of the cackle caucus, when you just sit and point and say, look, your stupid law is self-destructed. It's kind of your problem, isn't it? Or I suppose slightly more seriously, this would be the folks who say that the response should be this law has created huge problems. This is another one of them. And we need a new president, new Congress to solve this in 2017. I don't think that is going to be politically sustainable. You've got all of these people whose insurance has just been disrupted. At the state level, I think the incentives for a lot of governors and state legislators is not going to be to hold a line on doing nothing, both because they are accountable to a large number of voters who will be in a jam, but also because the political economy of this thing, state officials don't like throwing away federal money. We've seen that play out on Medicaid, where the state level Republicans have not been able to maintain the degree of unity that federal Republicans have been, precisely because of this dynamic. Now, it's a little bit different in this case because the individual mandate to some extent and the employer mandate to a very large extent are tied to the subsidies. And so that's a cross-cutting pressure. If a state government decides to establish the state exchange in the aftermath of a plaintiff win in King v. Burwell, they're also going to be deciding to resurrect those mandates, which are pretty unpopular. But all in all, this, I don't think, is going to be an environment conducive to Republican unity behind a do-nothing strategy. And I guess this is as good a place as any just to mention, it does seem to me that the dominant political fact about health care for many years now has been the public fear of the disruption of existing health care arrangements. If you think back to 2008, when Obamacare had not actually been fully conceived, President Obama spends, $44 million on ads pummeling John McCain for threatening employer health insurance. In 2009 and 2010, one of the top messaging items for the Democrats is this plan will do nothing to alter your existing health arrangements. And then the biggest political hit that the law has taken since passage was in the fall of 2013 when a bunch of people found out that they couldn't extend their health insurance and didn't have great options to deal with it at that time, and arguably since. Given that, I think that it would be a real mistake for Republicans to assume that there'll be a different public reaction this time. I think that the odds are that the sort of yanking of a large number of citizens around in terms of their health insurance is going to be a pretty big problem. So a fourth option for Republicans would be to finally push forward with a serious, credible alternative, a full-blown alternative to Obamacare that tries to enable many people who have been locked out of insurance markets pre-Obamacare to get insurance, but avoids some of the pitfalls that conservatives see in Obamacare. The problem there is that, again, time's getting short. Republicans have had 5 years to come up with such an alternative, have not yet unified behind one, although there are some strong ones that individual Republicans have come out for. Governor Bobby Jindal has recently discussed his health care plan, his set of health care policies as something Republicans should push forward if the plaintiffs win. This would be a repeal of Obamacare that also creates a deduction, replaces the current tax break for employer-provided health insurance, a tax break that, of course, predates Obamacare, with a standard deduction for people to buy health insurance for themselves. That seems to me to be an alternative proposal that is worse than non-responsive to the problem that we would be facing after King v. Burwell, because it not only doesn't solve the disruption problem, that is, a lot of people would not get anything close to the same subsidy they're getting under Obamacare now, and would still find themselves with a serious amount of disruption and difficulty. But at the same time, it would threaten people with employer-provided coverage. So you would actually see, you would take the existing disruption and then multiply it by several times. That does not strike me as a promising route for Republicans to go down. Actually, if anybody's followed my exchange with the governor, you'll find that when you make these points, he basically tends to sputter about how you're a big liberal.
You're not that big, Ramesh.
Yeah, or small liberal, I guess. The fifth response would be the one I personally think is the most promising is for congressional Republicans to come out for building an exit ramp from Obamacare. The idea here would be that states, especially the states that haven't established these exchanges, would be given by federal legislation a right to opt out of as much of Obamacare as possible. That is, in those states, not only no mandates, but no essential benefits package, none of the restrictive insurance regulations. You would still have tax credits. You'd have tax credits helping people who are currently on Obamacare exchange plans for a year or two. But in the future, you'd have tax credits that would go to people in those states, regardless of whether they're on an exchange or not. That is, you would be moving towards a very different model of health insurance markets, one closer to the kind of model that Senator Hatch and Burr and Congressman Upton have outlined in their Obamacare replacement legislation. But it wouldn't be the full-blown adoption of that legislation. It would be up to the states to decide whether they want to opt out or not. It seems to me that politically this achieves a couple goals at once. It allows the Republicans to say that they're for helping the people who are affected by this decision without expanding Obamacare. And it gives both federal and state level Republicans a way to do both of those things. And it does them, I think, in a fairly attractive way. But there are some serious political problems with this approach as well. One, it's very hard to see the Democrats going for it. So at the best, you'd probably just get the ability to say that we tried to help. Second, there would be some Republican resistance to it as well for various reasons. One of them being a concern that you're hearing a lot about on the Hill these days, that you don't want to box the next Republican presidential nominee in by having laid out what a replacement plan is going to look like, even in embryo. And there are ways you could deal with that have their own drawbacks. One way to do this would be, instead of giving tax credits to individuals, just give the money to the objecting state governments and let them decide what they're going to do with it in terms of helping get their people covered. We know, basically, I think, with any of these sorts of responses, what the Democrats would say in response, which is, well, this is all very interesting and we should debate it in the future. We think it's basically a terrible plan that leaves X number of people in the cold. But in the meantime, why don't we just pass a simple fix to solve this problem? And that's going to be a political problem for the Republicans. If you have a kind of standoff that extends for a while, I think you'd have a situation where you'd have sort of cross-cutting political pressures, where on the one hand you've got, as I said, the public's upset with disruption. You've got the possibility of a simple fix that Republicans are balking at. On the other hand, you've got the continuing unpopularity of Obamacare. You do have the possibility that a significant portion of the public will just decide, well, here's another way that this grand plan is not working for people. And you have the fact that although we are talking about several million people, we are not talking about by anything close to a majority of the American public. So it is entirely possible, I think, that you could have a standoff that lasts for a while. In which case the do-nothing option would end up triumphing, not by the design of most Republicans, but by the nature of this political debate.
Thank you, Ramesh, for bringing us back to the lowest common denominator, as we often reach there. The alternative playbook might be from Lincoln, which is that we must all hang together, or we most assuredly will hang separately, which might be a an alternative result. But we'll come back to this a little bit later on. Let's talk to Tom Haynes, who we thought we'd do something unusual. We'd find someone who actually has to sell these products and find customers who want them, as opposed to mandate them or think hypothetically as to how this all occurs. He's founder and president of TBP Solutions, a healthcare and insurance consulting firm that also acts as a broker for individuals and businesses looking for healthcare insurance solutions. It was previously executive director of Coca-Cola Bottlers Association, building a $100 million insurance program later sold to a publicly traded insurance company. So Tom's going to, I think, walk us through the insurance markets he's familiar with, as opposed to the ones we've heard about or other people have written about. Tom?
Thanks, Tom. Okay. Yeah, let me. Okay. I'll just start with a little disclosure. I am not a fan of the Affordable Care Act, but that is, and politically, that's probably where you would expect if you know any of my political activities. But I testified at the invitation of Democrats on the Affordable Care Act in 2009, and in fact was on the other side of a panel with some folks from Heritage and some of the people you would naturally consider that I would be in agreement with. And pursuant to that and consistent with it, I think I will disagree significantly with Professor Gluck. I will disagree significantly with Ramich, and I'll probably anger Ilya in the process.
So we're okay because we're Toms, huh?
Yeah, the three Toms, we've conducted all of our debates in private, and we've therefore come to complete consensus on everything, so there's nothing for us to disagree about. But when I testified, and my viewpoint on this, a lot of the things that are in the Affordable Care Act I was comfortable with, or became part of the Affordable Care Act, or comfortable with under conditions. It turned out that the bill as passed did not meet any of those conditions, so therefore I'm a severe critic at this point. And a lot of that is informed, I think, by some real-world experience. Where I will disagree with Professor Gluck and Ramich is I do not think that the post-King environment would be unstable or would result in collapse. I think from my experience before, during, and after the Affordable Care Act, I think this is not a day after tomorrow scenario. I think it's probably something that will create some real world issues. One of the things I particularly want to urge everybody to I think realize is Ramich referred to people losing coverage. That's not the scenario we're talking about. The Affordable Care Act still provides for guaranteed issue. It still provides for community rating. Nothing in King is going to change that. Everybody who has insurance, that policy theoretically would be good for the rest of the year and would be subject to guaranteed renewal. We're talking about price effects. That's all. We're talking about a pooling effect that is real, and I'm going to talk about that a little bit. But nobody is going to lose coverage. It may become more expensive under the deal that was done back in the fall after the King case and the Hobby case was decided in the D.C. Circuit. The carriers have the right to cancel the policy, but it has to be reissued on a community-rated basis, so nobody's going to lose coverage. Price, real world, and I will talk about that a little bit. So there is a three-legged stool. I agree with the concept. Frankly, I agree with an awful lot of what Professor Gruber has said, particularly some of his comments on the language of the Affordable Care Act on subsidies. But I do not think that either this case completely removes a leg or, frankly, that shortening some of those legs keeps the stool from being somewhat functional, at least as functional as it is today, which is not very functional. States may choose to create exchanges. States may choose not to create exchanges. And we'll talk a little bit about a scenario where we will have further litigation because there will be a debate over whether they did create an exchange or not. So there's lots of things that I think would ensue, none of which, frankly, to me, creates a huge political problem for Republicans. Now, I'm not going to be Pollyanna about this. There'll be a lot of controversy about it, but I do think that the consequences of a victory in King have not been well predicted. And I'm going to try to do my best to just tell you what's in my head on this. Let me start from the baseline, because I think it's really important for everybody to understand what we're talking about. Private insurance in America largely comes through employers. The bulk of that is through self-funded programs. The impact of the Affordable Care Act on the group insurance market, both self-funded and fully insured, is relatively mild, and to the extent it exists, it's almost entirely negative. In the group market, the regulations that in the fully insured group market, the benefit mandates eliminate a lot of flexibility that employers once had. There are major surtaxes in the fully insured market. Prices in the group market go up because of the Affordable Care Act. Theoretically, the SHOP solution and the small business tax credits would have been an offset, but those are a flop. Just my opinion, they're nothing. They've accomplished nothing for the small group market. It's not, it was not well thought out. I was lobbying for different legislation for the small group market when this happened. I thought the SHOP Act was very poorly conceived. It became part of the act because of Senator Durbin's influence and political concession to him, and it didn't work. And so there's not anything good in the Affordable Care Act, in my view, for the place where most people get private insurance. That's simply, and I don't know that there's a lot of a basis for debate about that, okay? You can argue that some of the regulations, improve the quality of group coverage because of the mandate coverages, but frankly, the keep your plan exception, which I'll talk a little bit more about, has essentially canceled that out because a lot of employers are simply keeping plans that don't comply with the Affordable Care Act. So what is there really? And nothing in any impact of King on the group market is going to be fairly indirect and will be both positive and negative, but won't be huge. Okay, so now let's talk about the individual market, because the whole concept of the Affordable Care Act was frankly to move people from the group market to the individual market, or move people into the insurance market that previously weren't. I've sold policies in both the groups and the individuals, primarily in, I'm going to talk about red states, because the change is much more pronounced in a state like Georgia or Florida or Alabama, or these states or even California, than it was in a place like New York, where a lot of the Affordable Care Act provisions were similar, in some cases less draconian than state law was. The individual market existed. Frankly, I did most of my work in the individual market in the month of December of 2013. Well, why was that? Well, of course, because the Affordable Care Act was coming out, and lots of people, including myself, figured out that the best thing you could do for people was to get them a policy in December of 2013 that would carry over into this year, because it would save them 11 months of pain under the Affordable Care Act. So I did a lot of helping of people on insurance in late 2013, because it was the last opportunity they had to get insurance in the market as it existed. In that market, in a number of states, and I quoted people in 10 different states across the country, it was quite possible, if you were under 30 and healthy, to get insurance for under $100 a month. $80, $90, $100, $110 a month. There's no available coverage, I don't think, anywhere in America under the Affordable Care Act under about $225 for anybody, no matter what your deductible is. And I'm not talking about a $100 policy with a $10,000 deductible. I'm talking about a $100 policy with a $2,500 deductible, because I got one for my daughter. Okay, so this was not a horrible environment if you were healthy.
This meeting has ended due to lack of activity.
Okay. Now, okay, so that's the young and healthy. Everybody knows, and there's been numerous studies under that the young and the healthy pay more under community rating. The whole idea, what community rating essentially says is somebody like me should get cheaper insurance and somebody like my daughter should pay more for it because you need to compress this because old people, vote more often than young people, and therefore they will reward you for making their insurance cheaper. That's a little cynical, but that's the concept of community rating. But interestingly enough, I sold a lot of policies, or helped a lot of people who were in their 40s and 50s with families, and again, could get insurance 40% cheaper in December of 2013 than they could have in January of 2014. I had the prices right in front of me. I was looking at it on a computer. I said, today it's this, tomorrow it's that. Sold people insurance effective December 31. Saved them $600 a month. I'm not talking about people in perfect health either. In fact, one of the great political sets of buzzwords that you hear about the Affordable Care Act was pre-existing conditions, right? That was the reason, because these horrible insurance companies were running policies with exclusions on pre-existing conditions. Well, I sold a couple of people policies with pre-existing condition exclusions because they knew the condition was basically treated because the doctor said you're fine now. So, okay, it was excluded, but they weren't going to have a lot of costs under it. Now, that's not, I'm going to give you anecdotes. I hate making policy decisions based on anecdotes. It's the worst problem that we've got in this country, and it permeates this act. But there are real world situations where the way insurance markets worked had very dire consequences for some individuals. But it was not as bad as people think in many ways. The individual market was functional in most places. It was a relatively negotiable experience. You could go online on ehealth.com or on other places, and you could get comparison quotes with summaries of policies. I've used those. I've used healthcare.gov. Frankly, I think the private online marketplaces work better than healthcare.gov as a shopping experience, but they're both shopping experiences, and I'm going to talk a little bit about how you have to think about them as window shopping experiences as opposed to Amazon, which is really a shopping experience. So there were choices. Most places there were multiple carriers with decent networks. It wasn't as horrible as people make out. Okay, so what happened afterwards? And what were the problems? Of course, and I go back to my legislation by anecdote, there were pre-Affordable Care Act poster children, real world people with health care problems who couldn't get insurance. Okay? Definitely some people in that category. I'm going to talk a little bit more about the politics of that in a bit. The numbers, I think, are smaller than most people imagine. As I said, you could get a policy with pre-existing conditions that was actually pretty good coverage at pretty affordable prices. And if you knew what your condition was and you go to your doctor and say, what do you expect my costs to be? You can do those calculations and accept the policy. I think a lot of people don't appreciate the degree to which HIPAA, COBRA, and other parts of federal regulation that have been there for decades solve the problems of a lot of people with private insurance issues. You lose your job, you change jobs, you go self-employed, you got COBRA opportunities. If in a lot of places there were state COBRA extension programs, and frankly, some of the states that you would think of as not not particularly liberal on these kinds of things, including Georgia, had both high-risk pools and they had other pool programs where the carriers were forced to take a certain pool of people with significant medical conditions and were forced to write insurance on them. And they were just allocated among the carriers. They all had to take a certain number of them. The prices were higher, but people got coverage. I got somebody coverage in one of those pools in 2013. Her coverage was 3 times more expensive than it would have been if she was completely healthy, but it cost her about 1/4 of what her medical costs were going to be. So, believe me, this was not, the pre-Affordable Care Act market was not as horrible as some people make out. Now, what are things like today? And let me point out something again. You see all the numbers on exchange enrollment. I think we all know that there was a number published at this point last year that was around 9 million, and it turned out to be 6.4 million. So please take all the numbers. Please take all the numbers you read in the paper and you realize that the ultimate number is going to be a lot lower. There are still more people with individual insurance off the exchanges than there is with individual insurance on the exchanges. Okay? Almost everybody getting coverage on the exchanges is getting subsidies. But there are more people who are still getting their insurance off the exchanges. Okay, so now there's going to be a price effect on that, but I'll talk about that in a second. Young people are paying more. If your income is over about $35,000, subsidies don't offset the increased costs relative to what you would have had in 2013. People in the 40s and 50s with a couple who's making $50,000, the subsidy is chump change, not worth having. They just go buy insurance off the exchanges. There might be a little bit, but it isn't worth the hassle. And one thing I would point out politically, community rating has far more victims than it has beneficiaries. But of course, the beneficiaries benefit by a much larger degree than the victims suffer. So what I think real world, and I'm just going to skip the rest of the presentation, I think, is that talking to folks, the vast majority of people out in the country are paying more for their health insurance post-Obamacare. Politically, that's one of the reasons why the polling numbers are so bad. Now, Americans are sympathetic to the notion that there shouldn't be people out here who die because they can't afford insurance. So take, there's all, there are a lot of cross forces here. My view is that if King is decided by the Supreme Court in favor of the plaintiffs, what will happen is prices will go up. People won't lose coverage. People will lose subsidies. The loss of subsidies will cause some people to drop out of the market. They're going to tend to be lower risk people that are improving the pool today. That's all true. The carriers have figured out how to price this. Every one of them has a price for every policy that will go out. If the Supreme Court says in July that 2 days later the subsidies go away, the carriers will have prices online that's the day in between. This is not going to be a nuclear holocaust. They've figured this out. They have a pretty good guess as to what's going to happen in the pools. We will survive. People will still get insurance. I think it's going to end up being a bunch of hullabaloo about something very important. I think the case is very important. I think it's important constitutionally, it's important politically, it's important for healthcare policy. But we'll survive. Now I'll go ahead and anger Ilya. And let me go down to this last slide. Okay.
All these slides will be posted on the AEI website, so you can get the missing links. Okay.
I actually think PowerPoint's unconstitutional and as applied in most uses.
Okay. So let's talk about the keep your plan guidance and what the administration could do. What everybody talks about in this Holocaust scenario is the combination of no subsidies with community rating and guaranteed issue. And gosh, that can't work. Well, there were 11 states that had some version of that before the Affordable Care Act, and there were only a couple of states that you could really say had, absolute disastrous individual markets, New York being the primary example. Some of those other states, you could buy insurance there, and it wasn't a good policy combination, but it wasn't a disaster without subsidies. Anyway, in the keep your plan scenario, the secretary wrote a letter to all the state insurance commissioners saying, we're going to give you a choice, okay? You can either tell the carriers they can keep their plans, ignore community rating, price them however they feel like it, do whatever they choose in renewing policies. Or you can say you can choose not to do that, right? Now, obviously, you would see this as just another example of the violation of the rule of law, and I'm not sure but I agree with him. But everything that people talk about the Affordable Care Act in terms of the need for federal uniformity, the need for a consistent framework, the need for a single national health care policy, whatever, it just went right out the window with one letter, okay? So why don't they write a second letter, okay? And they say, geez, the Supreme Court issued this decision. We don't agree with it, but we'll exempt you from community rating for the next 18 months, 2 years, or until further notice. And you can let the carriers go right back to what they were doing in 2013. And you can issue those $100 policies to a healthy 28-year-old because you knew that was a good price and you were going to make money on it. You had it all actuarially figured out. Nobody has to drop out of the pool. We're not going to give you an exemption from guaranteed issue, but we'll give you a 20%, 30%, 40% rate band to rate up policies for people with some health conditions. And you can sort of choose what to do if you're in these 36 states. So not a lot of real law involved there, but, as you just pointed out, there's an awful lot of things being made up as they go on this, and they could make up another way to go if they wanted to. And frankly, I think it might be a very sensible regulatory approach. I don't think HHS should be deciding this, but I don't think HHS should be doing a lot of the other things they're doing. Again, I just don't see this as a scenario. I'd also like to make one comment about Professor Gluck's fair notice argument. She's kind of defenseless at this point.
I know she is, but hopefully somebody in the room will rise to defend her. Or, I'll defend her and switch my hat. There were some states that said, hey, we're not going to create an exchange because it will exempt our state from the employer and individual mandate for the most part. So there were a few people who got this, had the notice, and actually talked about it. Interestingly enough, there are a few states that had exchanges and have taken them down since the lawsuit was filed. Now, what does that tell you about fair notice? There's a case going through the Supreme Court. Lots of people are writing it. It might win, and Oregon takes down their state exchange and goes to healthcare.gov. So what is Professor Gluck? I think that undercuts Professor Gluck's argument that the states would have done something differently if the statute was clear. The scenario now is out there fairly clear. I wrote an email to the ranking Republican in the Oregon legislature, said, you might want to talk to your people to be sure if they want to do this. And they did it. Now, let me give one other example of what I think may happen.
I don't think so.
Okay, go ahead. I'm done.
You sit down with an insurance broker, and before you know it, they've been talking to you for an hour, and you bought all kinds of stuff that you didn't know you were going to go for originally. All right. And I had to preserve a little bit of time because Ramesh was a bit of a Debbie Downer on this whole type of stuff. And I just happened to have a few extra slides. I don't know where I found them from. So let me just get out of here. And in regard to Ilya, the appropriate philosophical approach, you go back into 18th century, Lord Acton, power corrupts, absolute power corrupts absolutely, PowerPoint corrupts pointlessly. Nevertheless, I'm a practitioner. All right, so what happens in politics and consequences, and maybe a little different take on this. Ramesh talked about some of this. It really comes down to who gets blamed more, and whether what used to be the president of the future flips around, where basically all the problems of the present are on the Republican side, as opposed to when they're first starting this up, as opposed to what might be the benefits down the road in the future, and that's a bit of it. But there'll be some other changes, including, I think, a reload of Medicaid as some of the effects. What will the states be doing? Unquestionably, there'll be some red state backsliding. Now, keep in mind that the governors are a little constrained because in most cases, their state legislatures won't let them do it, although there are exceptions to that. And certainly there'll be the effort. This will be like the day after Hitler invaded Russia, and all the folks who were previously on one side of the equation flipped over and said, you can't do this, you can't have a possible rental of an exchange and have these things. Wait till the day after, all those impossibilities will become possible, and there'll be rules being issued or other interim guidance and blog posts and tweets that say it's possible. So the question is, once upon a time, I think the states would push back, ask for some bargaining leverage. I think the exchanges are poison to a lot of states, and even though that's one hypothetical route, less likely to happen in the red states. But there's a lot of bluffs been going on in this field, so suddenly all the two-sided finger pointing, there's less air supply for doing that indefinitely. As much as we imagine that Congress can't do anything, and that's a reasonable first assumption, there are limits even on Capitol Hill to procrastination and polarization when people are desperate to get reelected and get a lot of hassles coming at them. So there'll be a push for some urgent transition fixes. The question is what in return for it, and one of the things is to think of a liberal environment in which, small l, different choices in health insurance and health care and alternative subsidy delivery. And those will be at least pushed to some extent. Now, the two basic Republican approaches are either throw it to the states because we don't know how to do it, or to hand out some more money to folks. That's this two Santa Claus theory of fiscal policy I've talked about before, which is you can't compete by spending, but if it comes through the tax code vending machine, that's fine. We'll just give it to our folks rather than poorer folks, perhaps. And the federalism is a little bit situation-based and perhaps a little selective on that front. Now, we get a lot of rhetoric about the state laboratories of democracy. At least if one state does the wrong thing and puts the wrong formula together, it only blows up its state, not all 50 at the same time. So you have a chain reaction and wired on that front. The question about, and the different options, and Ramesh talked about some of them, whether it's a capped appropriation, whether it's putting the S back in CHIP, whether it's thinking of some other type of health check proposal. That talks about how to get the money out the door and get it to people. What it doesn't say is how much choice will really come about if the states are brokering this and deciding what they can make as available to folks as opposed to the wider open choice in the marketplace, and whether it's really individual empowerment or politician-to-politician lendings like we used to see in developmental aid from government to government. I also have to remind some folks on occasion that state officials are also politicians. They just lack the market share and opportunity that federal politicians have, or as it sometimes got me in trouble, I've described them as mice studying to become rats. You have to understand the food chain involved here. Mice live off of grain, whereas rats feed off of human garbage. They tend to congregate in places where there's more human garbage around. Capitol Hill, for instance. You just need to think about actually who you're empowering and thinking that, it's a virtuous free market because the states are running it, as opposed to the folks you just didn't like at the federal level. So what's going to be called for here is a little bit more discipline in negotiations, deciding what are real priorities. And this is the big list because the lawsuit's being filed to basically get relief from the individual mandate. If you win the case, maybe you'd like to still have it as opposed to give it back. Get rid of the employer mandate. That would be one under the case if the petitioners win. So that's like a good starting point to not give back what you just won in at least perhaps 37 states. We haven't talked as much about loosening some of the benefits requirements. It doesn't save some money, but it's worth doing that in terms of essential health benefits and minimum essential coverage so that state regulation is at least better than uniform federal regulation, and you move in the direction of any willing seller for any licensed product approaching the extreme. Keep in mind that the risk corridors are not popular, and that should be put on the table in terms of putting a little pressure on the folks who are working in Vichy government international relations. And again, the alternate subsidy ramp is the big deal on that front. Now, will Obama negotiate with these, lunatics on Capitol Hill? This is Sigourney Weaver. It's a little dark there from Ghostbusters. We have to remember what Dr. Peter Venkman said when she had been taken over and became Zool. He said, I make it a rule never to get involved with possessed people, but actually it's more of a guideline than a rule. President Obama will be in that situation in a short period of time in the event that he suddenly has to negotiate, despite his first set of preferences. Okay, who winks or blinks first? One thing, unfortunately, we haven't talked as much about, I won't get into deep detail on it, but I've been running the traps on this. There's some budget constraint problems. I've heard the assurances from the staffers that we can work our way out of this with directed scoring. They need to make a better case than they have thus far. There's pay-go problems. One of the ceilings on what you can get out of negotiations is probably going to need 60 votes, and you're going to need some Democrats. And you look that over, but this is going to be post a Supreme Court decision treated as new money. And if you haven't parked it from somewhere else or decide to go into Medicaid funding for the expansion populations, you're going to have trouble making the dollars meet and getting over a 60-vote threshold probably twice. There are differences of opinion on this, but I'd like to hear someone make a more persuasive case that it's not a problem. I haven't heard it yet. Winners and losers, there's going to be a mixed bag. And the way politics works is you want your side to be, your coalition to be the winners and the other folks to be the losers, then I think you'll see those type of splintering effects. Part of that is how progressive and income-based any type of new subsidy regime is. If you don't want to run everything through the IRS and have everything, month to month, you might want to think about annualizing things, but I don't know if we can get away entirely from some type of income sensitivity in the way subsidies have occurred, given how massive that is right now. You might scale it back, but getting to just a flat zero, everything the same for everyone, might be a far reach beyond where we are. The imagery is important in this one. Keep in mind, if we're in late June, this is after a very bad tax season. We're already seeing signs of it. Individual mandate, if it wasn't popular before, will be less popular afterwards. The IRS, which is behind this rule, will have just given people a lot of disgruntlement while you're on hold and wondering what's going on. Insurers are the folks who are getting all this money, not individuals. They're not real popular either, so you can play this several ways politically. Again, the governors versus the state legislatures is a battle that's continuing on, and certainly some governors are a little wobbly on this, and their view is it's someone else's job. We're willing to take full responsibility for distributing money, but not the blame if something goes wrong, kind of like Nixon in Watergate when he did that type of posturing. The other thing to keep in mind is infrastructure and timing. You can't get dollars out the door without them being connected to something that's real. That's hard to manufacture quickly overnight, so that's why some of the proposals have been the way they are, and timing matters a lot. If you hold firm in the early going, someone has to blink before someone else, but you can't just go into overtime. You definitely need to be ready with something in a hurry by doing your work in advance. So what's the only common ground when politicians get together? They can agree on one thing, handing out other people's money. That's not really a debatable point. The question is who gets it under what terms. That's where we'll find it. And as Yogi would say, though, we might think about doing it differently, which you could give people cash just as good as money rather than health care. If you don't want to do that, why do you want to give them health care? Why not go direct on that? Well, we don't want to do that. Okay, then why are we doing the other thing? I'll skip over that. That's just basically the usual healthcare industry stuff. The bigger points I want to make is in the midst of this bonanza over health insurance and healthcare, we always forget that there's another world out there. This is not where the healthcare universe is what everything else revolves around and all the money needs to go into it. It turns out we're in a Copernicus world where the health sector is part of a larger ecostructure and needs to think about what its claim upon those resources are. It's not unlimited. A little strategery here, though. Ultimately, you've got to decide among the opponents, is this going to be a George Kennan-type containment where you just have to hold still and hold off an implacable foe while you build up your own staying power? Or is it a John Foster Dulles rollback going into the occupied territory? It's a little bit of both, but it's certainly neither of those two extremes in isolation. And then finally, we'll figure this out because, as H.L. Mencken said in talking about America's natural criminal class, we ultimately get what we want, and sometimes we'll get it good and hard. All right, thank you very much. We got about 5 minutes for questions, and Carl was patient before. If we can bring a microphone back there, and we'll get one in another minute. Go right ahead.
Hi, Paul Heldman from Potomac Research Group. I have a question for the lawyers on the panel. I'm wondering if the court rules in favor of the challengers, if there's any precedent or any reason to believe that the court would remand the case back and create some sort of transition period of any sort.
Tom?
I don't know of any. It seems to me that that's not really a remedy that's available under the Administrative Procedures Act. One would think that if the regulation is contrary to law, then it ceases to be effective as soon as the judgment is entered.
Well, I don't see a remand. That would imply that there was something left for a lower court to do, but they could certainly say that the mandate won't issue for a certain period of time. They have, as it is, I believe there's a certain amount of time before it goes into effect. It really depends, and yeah, the APA plays into it a little bit. So the court's the court. It could write the opinion in a way that might give the administration leeway to put in some sort of delay, or might give insurers some leeway. So there could be a temporary stay of, not stay, but kind of delay of the mandate issuing. Although it doesn't happen very often. Much more likely would simply be to say, okay, this is the ruling. Other lawyers can figure out what the consequences are in terms of when this actually goes into effect, what parts go into effect, when insurers no longer get subsidies, et cetera.
There's some other operative rules, as you know, where non-payment of premiums doesn't bounce you out right away. The insurers who want to exit from their plans have to go through a few steps before they can get out. So there's more than just the 25 days in reality.
Thank you, John Graham, National Center for Policy Analysis. My question is for the lawyers, and I've always been led to understand that getting rid of the tax credits in the 36 states and getting rid of the employer and individual mandate are bound together inextricably. Is that correct? Or is there a possibility that the Supreme Court could throw out the tax credits but keep the mandates in there? Or is the law written too tightly that you can do that?
Actually, the question of the mandates isn't directly at issue in King, but the way that the employer mandate is written, there's a dual trigger for the penalties under the employer mandate. One is the failure to offer coverage opportunities in accordance with 4980H. But the other is that a full-time employee gets coverage from an exchange and is allowed a tax credit.
Yeah, if maybe I could just add to this a little bit, because I am a lawyer, but that's not why I'm here. But I do understand the legal issues, I think. The individual mandate is triggered by affordability after subsidies. So if the subsidies go away, there's a lot more people that are no longer subject to the individual mandate. So that really is not a universal end of the individual mandate, but yeah, economically, I think Mike Cannon has written on it. It's maybe 85 to 90% of the people in these states.
Oh, the latest briefs on the other side have got it up to 99%
Okay.
under a RAND model, which may not be the right
Okay.
model.
Anyway, but
that's extreme.
Yeah. So that's I think the answer on the individual mandate. On the employer mandate, the government has pointed out there's a little bit of a exception there. As Tom said, the employer mandate is only triggered if if you don't have coverage and one of your employees gets a tax credit. One. If all your employees are in one of these red states, then there is practically no employer mandate. if you've got employees in Virginia and Maryland, and one of those employees goes on the Maryland exchange and gets a subsidy, then you are subject to the mandate, even as a Virginia employer. So,
Go ahead, Carl.
Yeah, just
We'll come back.
if you win, you lose category. So if the upshot of this case is the states have to affirmatively, the legislature, create or accede to creating an exchange, whether it's a renta exchange or a real exchange, I think that gives momentum to the Medicaid expansion, because now you're going to have 2 buckets of money on the table, not just for poor people where the health care providers are getting paid 70-cent dollars. They're going to be getting paid 110-cent dollars or $100 through the exchange. So what I thought Ramesh's comments were very brilliant, but he didn't quite understand the power that you ridiculed, Tom, of the lobbies that brought us this law. Pharma, hospitals, doctors, all the interests in healthcare and the insurance companies and the consumers. And if they have 2 buckets of money on the table in my state, in Virginia, I think it's going to move through a lot faster. Or it could. I'm sure some of the states still won't. The second point, and it's very brief, is
I was shaking in my boots at that first one.
well, the drafting. Now, if you guys, I thought we were going to talk about language here, about the Republican alternatives. I thought there was some real language, and the standard for drafting is higher than it used to be. Now, whatever you draft as a replacement bill is going to have to be very tightly drafted after this case. But what I think is in these bills is, if you keep, the state shall give, the federal government shall give the states a boatload of money that they can spend on people to give them some kind of coverage if they keep continuous coverage. That's about the state where I think these alternative bills are at. So what does boatload mean? Does it mean a metaphorical boat that can increase with inflation? Does it mean an actual boat that you can pile stuff on? Does it mean a boat that can leave Washington and actually stay buoyant on the way to the ocean?
Captain Indexed. Move on.
Okay, I'm done.
Joel, one last question from Joel.
Hi, Joel Zinberg, AEI. Ramesh, you've really focused all on the problems that Republicans are reputedly going to have if the plaintiffs win in King. But it seems to me Democrats may be in more hot water, because the ACA has been enduringly unpopular. Everyone knows it was passed without a single Republican vote. You've had the president come out saying he's going to veto any alternative. You've had Democratic senators saying they won't cooperate with any alternative, saying they're not interested in any other proposal. If Republicans can cobble together something, whether it's the latest Hatch revision of their proposal or some other proposal, and it makes its way sort of towards legislation, and then you have the spectacle, a la a government shutdown, of Democrats stonewalling, it seems to me that puts the Democrats in a much worse position, and they'll be in the position of having to compromise and scramble to come up with something and cooperate with Republicans to actually have an alternative. I'd just like your comments on that.
Well, maybe it'll work out that way. I think that it is unlikely to work out that way, but there's just a limit on how much we can predict. I mean, I suspect, the way the media is not going to be going out of its way, I think, in general, to be holding the Democrats responsible for any problems that are arising in the aftermath of this litigation. Republicans certainly will be trying to do that. I'm not sure which way public opinion will come out. And even if I did, I suspect there'll be more on the Republicans should act quickly side of things, but maybe not by a huge margin, maybe by certainly a survivable margin. Tom, number 3 here, has provided us with some reasons for thinking that the situation won't be politically apocalyptic, and I think a lot of those considerations are right. I think I think that's a useful corrective to the sorts of things that some folks say. I think he may be taking it a little bit far. I think that a big price spike ends up getting processed by the political system pretty much the same way that a big coverage elimination would be. That is, people will still hoot and holler about it on Capitol Hill and in the media. All I would say is Republicans would be better off having something to bring to the table, regardless of what the public reaction is, than not having something.
Fair enough, and we could take a vote here, but I think we're going to take this one to a higher court. What we can probably predict is that around about June 30th, we'll be busy again, and we'll probably also be processing a decision that same day on same-sex marriage, just remarkably enough. But in any case, we thank you very much for your attention, and this one's still going on. Have a good day.